Good evening. My name is Andy Carlson, and I will be presenting the Cedar Rapids Community School District versus Garrett F. Case number 961793, 526 US 66, 1999. Um, so, the background behind this case is Garrett F., and I'm going to use his actual last name because he's a very well known advocate in the state of Iowa. His name is Garrett Fry. He was in an unfortunate accident where he actually fell off the back of his dad's motorcycle because he was wearing a blanket. He was coming home with his dad and he was had a helmet on, but he was pulled from the motorcycle and unfortunately the helmet saved his life, but he did sever his spinal column. So after that, he was a C4, C5 quadriplegic. He was ventilator dependent. He ended up spending the next 11 months in the hospital, where he faced a lot of challenges, obviously, to relearn simple tasks as a 4-year-old. He obviously had to figure out how to drink water and all the complex things that come with becoming a quadriplegic. Some of those simple things become very difficult. Um, so he was in the hospital for 11 months. Luckily, his mental capacity was not affected. And so he was still able to speak and control his motorized wheelchair with his puff and suck straw and operated his computer device, which responds to his head movements. In kindergarten, he had an 18-year-old aunt that would accompany him to school. Then his family used insurance money um, from the accident and other resources they could scrounge up to basically hire a nurse, which they were able to do through fourth grade. And some of those things that he needed were bladder catheterization, suctioning of his tracheotomy tube, and obviously the observation of his respiratory distress to make sure that he was doing all right. Not sure. There we go. Until, like I said, fourth grade, that worked. And then in fifth grade, his mother in 1993 asked if his mother's name was Charlene, asked the school board if they could supply him with nursing services. Um, the school district said basically, we've already been, spending up to $30,000 a year, or up to 12,000, excuse me. That's what they figured, and they don't want to spend an additional $30,000 a year. So the board refused, saying such services were not part of the school health care plan, but rather medical services, which were not covered by IDEA. After the parent requested the hearing, of course, this went to an administrative law judge, which decided that the school board was responsible for the services. A federal trial court in Iowa affirmed this, concluding that such services did not fall within the medical services exclusion clause of the IDEA related services provision. Um, you know, which you can see right there, was not deemed excessive under 34 CFR SS 300.16A, B4, and B11. So then it went to the Eighth Circuit Court of Appeals, which noted that the Supreme Court's earlier decision, and this is an important case because this is kind of what they use this precedent, is the Irving Independent School District in versus Tatro, which was a 1984 decision. That had established an unquestionable standard for which I'll quote as saying, whereby the services of a physician are exempted, but services that can be provided in the school setting by a nurse or qualified layperson are not. And since Garrett's services obviously didn't require a doctor, the court upheld the lower court's decision. On November 4th, 1998, the case was then heard in front of the Supreme Court. And given the court's decision in Tatro, the school board did not argue that Garrett's case constituted medical services. Instead, it proposed that several other factors should be considered, and those included whether the care is continuous or intermittent and the expense of the service itself. Luckily, Garrett won. On March 3rd, 1999, they ruled 7-2 in his favor that the 1990 Individuals with Disabilities Education Act, which we know as IDEA, requires school boards to provide continuous nursing services to disabled students who need them during the school day. John Paul Stevens wrote the majority opinion, And he noted that the school district's proposed test was not supported by the statute's text or any other regulation. Focusing on the issue of expense, the court rejected accepting a cost-based standard, arguing that doing so would have required it to engage in judicial lawmaking without any congressional guidance. In Tatro, they concluded that the Secretary of Education had reasonably determined that the term medical services referred only to the services that must be performed by a physician and not to school health services. In the court's view, Congress intended that the IDEA to open the door of public education to all qualified students and to require school boards to educate handicapped students or children with non-handicapped children whenever possible, as we know from our class that we've learned. Under the IDEA and the court's own precedent, the justices ruled that a school board must fund such related services to help guarantee that students such as Garrett were integrated into the public schools. Thus, the decision of the Eighth Circuit Court was upheld. There was 2 dissenting votes, like we said, it was 7-2 vote. Clarence Thomas and Anthony Kennedy were the dissenting 2. They asserted that the majority's interpretation transforms a law that was designed to boost educational opportunities into a mandate for medical care, and that the majority's interpretation strains congressional limits on how Congress can put financial obligations on the states. Like we talked about here, some of the conclusions would be that medical services referred only to services that must be performed by a physician and not to school health services. IDEA authorizes federal financial assistance to states that agree to provide such children with special education and related services as defined by case number 1401A17. It also talked about excessive costs are defined as by the means those costs that are in excess of the average annual per student expenditure in an LEA during the preceding school year for an elementary school or secondary school student as may be appropriate, and that must be computed after deducting. Obviously, the district was not super happy about this. The district's lawyer named Sue Letta-Johan Seitz expressed dismay at the budget implications for the ruling in this case, and said that special education has really come to the forefront in the last 10 years. The nature of the claims are very different. Medically fragile children were not in school before, which is true. Personally, I believe that obviously the right decisions were made. They said they believe that in excess of 20,000 students possibly were given, the opportunity now to go to school. And so I think that is a win. The more kids in school, the better. The Irving Independent School District versus Tatro case became like the test that formulated the Department of Education for interpreting the related services provision of the special education law. I forgot to erase that last part. Implications. Medically fragile children who are not in school before now are able to go. This is a win. It requires school boards to provide continuous nursing services to disabled students who need them during the school day. It obviously set precedent for other cases, right? This is now the expected precedent or standard from here on out, or expectation, I guess you could say. I guess for us, never deny services because of made assumptions, right? This is something that you obviously need to talk to your legal team about, or your lawyer. Contact your district's lawyer before issuing a statement to a parent with regards to denying services. The last thing you want to do is end up on the front page of the Des Moines Register for some boneheaded move, right? As far as questions to consider, I guess my question is why does it seem that school districts are always fighting tooth and nail to deny services? It seems like they don't want to pay. It's not their money; it's the taxpayers' money. So I've always wondered that, and I've heard, in passing and over my, years in school, kind of this, I guess, under the radar thing where administrators don't seem to really want to pay for services, and I find that strange. So I guess my next question, follow up to that, then would be, do we as future administrators need to change our mindset towards cases like these? Do we do our best to try and help them as opposed to maybe fighting that? And then, if you feel like it and you think you have a good argument, maybe against it? Do you agree with the Supreme Court's decision? Why or why not? Um, Let us know. All right, there's my slides. Hope everyone enjoyed the show. Thanks.